Hi, good afternoon if you're on the East Coast, and good morning if you're way out west. My name is Aaron Lacey, and you are listening to Safeguarding the Data and Your Compliance program, which occurs at the crossroads of the U.S. Department of Education and the GLBA, or Graham-Leach-Bliley Act. This is a webinar being offered up by Thompson Coburn as part of our Higher Education webinar series. Thompson Coburn, if you don't know, is a law firm located here in, well, some of us are here in St. Louis, and we also have offices from coast to coast. And actually, our presenters today are over on the East Coast in our Washington, D.C. office. While folks are joining, I'll go through a little bit of our housekeeping. First of all, if you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We are going to gather those and attempt to answer as many as we can towards the end of the webcast. A copy of today's slide deck is available in the resource widget. That's also there at the bottom of your screen, and we encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical questions and issues located in the help section. And that again is a widget there at the bottom of the screen. We're big on widgets here. The webinar, if you're an attorney type, is approved for continuing legal education credit. It's accredited in California, Illinois, and Texas for 1 hour of general CLE, and in Missouri for 1.2 hours. The webinar is also CLE accredited in New York for 1 hour of experienced and transition credit. We award CLE based on attendance for the entire 60 minutes. So if you are joining us and you are an attorney type, please make sure that you log in. Through the presentation, you will also notice that we have certain secret words that are displayed. And if you are looking for that CLE credit, please make sure when those items pop up to tap on the correct choice so that we'll know that you're still engaged and paying attention. At the end of the presentation, we'll have, after the Q&A, and we've concluded, a survey. If you have a moment to fill out the survey, we always deeply appreciate it. I say every webinar, and it is true that we read those and we take them seriously and try to think about how we can improve future webinars based on the feedback that we received. If you're one of the few or many that happened to tune into our webinar yesterday, as well as today, then you know that we've already received your survey comments from yesterday and taken them into account. I mentioned earlier, Thompson Coburn is a law firm. That means the folks who are presenting today are attorneys, and we have within our law firm, which is a fairly large, we have about 400 practitioners. We have a group of individuals who spend all or much of their time serving higher education, colleges and universities, and in some instances, providers that offer services to colleges and universities. They are part of our higher education practice. I'm the host of our webinar series. My name again is Aaron Lacey. I'm the chair of the higher ed practice, but today my duties are limited. I'm only setting up and moderating Q&A. The folks you're going to hear from and who are really expert in this field are Jim Shreve and Katie Wendel. Jim is partner and chair of our cybersecurity practice and advises folks in many different industries on a range of matters relating to privacy and cybersecurity. Has done that for, as it says on your screen, over a couple of decades. Since coming to our firm a few years back, Jim has been kind enough to work with a significant number of our higher education clients and has actually over the years become involved with NACUA and done some work with the Department of Education as it has developed and matured its views on privacy and cybersecurity. And Jim's going to be leading off our presentation today. And we'll be joined by Katie Wendel, a counsel in our higher education practice. Katie works most of her time with colleges and universities as part of the higher ed practice, but also often coordinates with Jim. So we have, like you can see, someone from our cybersecurity side and someone from our higher ed side, and they have come together to provide expert guidance and counsel to our institutional clients on these topics. So with that having been said, I'm going to pitch it over to Jim to take you through the syllabus for today's presentation and get into the substantive content. Jim, it's all yours.
Thank you very much, Aaron. And thanks to the Higher Ed group for having me again today. I always greatly enjoy being on these webinars and talking about these issues and working with our higher ed clients on all this. So today the topic is primarily around the Gramm-Leach-Bliley Act, and specifically how the Gramm-Leach-Bliley Act impacts institutions of higher education. So we'll look at what is GLBA, what is the safeguards rule, how does the Department of Education come into the picture for GLBA. We'll look a little bit at the FTC, who is the primary enforcement agency for purposes today of the Gramm-Leach-Bliley Act. We'll look specifically how the safeguards rule itself is enforced. What are some of the issues that can come into play with states, because states are permitted to go beyond GLBA requirements, and some have done so. And then we'll take some questions and give some closing thoughts, as well as look at some TC extra credit items. So with that, what is GLBA? Its actual formal name is the Financial Services Modernization Act of 1999. And interestingly enough, it's how I got my start in privacy and cybersecurity. It was one of the first things I dealt with as a young attorney. And so I've pretty much literally been dealing with it my entire career. It was a significant overhaul of how financial services in the United States is regulated. It is an extremely long act, over 1,000 pages long. And one part of it that we're going to deal with introduces the idea of privacy and security requirements for the protection of non-public personal information, and that being a key definition here. And so let's look into what GLBA says and what it does. So in terms of the entities, GLBA applies to financial institutions, and you may be thinking quite reasonably, we're a university, we're not a financial institution. Well, let's look at how you probably are. To be a financial institution, you have to be significantly engaged in activities that are financial in nature. Now, that goes deep into financial services regulatory law, and includes a lot of different activities that have been deemed permissible for banks to engage in, or for their holding companies to engage in. And so it includes a whole lot of things. One of the things that's included in there, not surprisingly, is lending money. And in issuing the safeguards rule, the FTC looked at these definitions and said, well, higher education, you lend money to student borrowers, and therefore, and you do that in a systematic way. And so that makes you significantly engaged in activities that are financial in nature. Now, one of the things I would note here, I said that these requirements apply to financial institutions directly. Now, they don't apply to service providers, and all financial institutions are reliant on service providers to do many things. So there are going to be a number of things that apply to you but don't automatically apply to your service providers, and that can be a tension point. And we'll talk about that a little bit more later on. So there are two important definitions that define what data is covered by GLBA. And the first of those is this definition of personally identifiable financial information. And so you'll note it includes, it's information that a consumer provides a financial institution to obtain a financial product or service, or about the consumer resulting from a transaction with a financial product or service. Now, what I would note there is that the term financial in there, because the information itself doesn't necessarily have to be financial. It's information that relates to an individual in them obtaining a financial product or service, but not that the information itself is financial. So you may have things that wouldn't seem financial at all. It could be an individual social security number or some other government-issued ID number. It could be things that relate to the individual that are not financial at all, but you obtain them in providing the financial product or service. That's covered. That's PII. And I would also note that it includes the fact that a consumer has been a customer of the financial institution or obtained a financial product or service. So the mere fact that in the student aid context, that someone has received federal financial aid from the school, that's covered. So that's not something that you can just freely disclose. It's subject to the limits of PII. The second definition is non-public personal information. Now, this is a subset of PII, and it includes, so it's any list or description or the PII itself that's not publicly available. So essentially, this takes PII, removes those things that are publicly available, and that becomes non-public personal information. And so most of the requirements of GLBA relate to NPI. So that's really the key one to know, but you can't really know what that means without understanding PII to begin with. So what are the requirements of GLBA? So we know the entities, we know the data. It has two main types of requirements. The first ones are around privacy. So under GLBA, when a customer relationship is created, essentially when a financial institution provides a financial product or service and creates an ongoing relationship with an individual, that's the customer relationship. And so at the beginning of that, you're supposed to send out a privacy notice on that customer relationship is created, and then annually during the duration of that customer relationship. Now you may be saying, what? We're not giving out GLBA notices. Don't panic. I mean, in the higher education context, there's a reason for that. And higher education is addressed differently than most financial institutions for the privacy provisions of GLBA. Another thing that GLBA does is it imposes limits on the ability of a financial institution to share non-public personal information with non-affiliated third parties. And so in general, unless the information sharing is permitted under one of the exemptions, a consumer must be given the opportunity to opt out of the financial institution sharing of that NPI with an unaffiliated third party. And those exemptions include things like sharing with your service providers, sharing for legal compliance purposes, a lot of the things you might expect. But what it doesn't cover is if you're sharing, say, for the third party to market to someone. And as I noted, states can go further than what GLBA requires. And importantly here, there are some states where GLBA says you have to get a consumer's opt-out before sharing the data. Some states require an affirmative opt-in, most notably including California, Vermont, and North Dakota. So then the privacy provisions are important, good to know, but security is really what we're here for today. And so the language that's on the screen right now, I'll give you just a second to read it. In a fairly significant bill like Gramlich-Bliley, where the security provisions are such an important part, this is all that Gramlich-Bliley says about data security. This is the entire language that is included there. So what I think it shows is that there's a very important role played by the rulemaking here, because Gramlich-Bliley only gives very broad strokes around how you have to protect this data, this NPI. So it necessitates the agencies involved writing rules and making clear just what they expect. So in terms of Gramlich-Bliley rulemaking, there's a split between the privacy requirements and security requirements. Prior to another law called the Dodd-Frank Act, which was enacted in 2011, there was no split. So the same agencies dealt with privacy as dealt with security. Dodd-Frank split this up and created this new agency called the Consumer Financial Protection Bureau, the CFPB. And privacy was considered a consumer protection function under GLBA, and so it was given to this new CFPB. And the way that GLBA works is that for certain regulated entities, they are given to the authority of a particular agency. So, for example, if you're a broker-dealer, or other SEC regulated entity, it's the SEC's role to do the regulations. But if you're not named to a particular regulator, you're given to the default one, which in this case is the CFPB. And the CFPB's rulemaking for the privacy provisions of GLBA is Regulation P at 12 CFR Part 1016. The security requirements of GLBA, it kind of works the same way, is that certain entities like banks are given to the banking regulators, commodities firms, the CFTC. But if you're not listed as going to a particular agency, you're given to the FTC, Federal Trade Commission. And that's the case for higher education. So in higher education, being a financial institution, you're subject to the FTC's version of the GLBA safeguards rule. That has been promulgated at 16 CFR Part 314. So,
sorry. Hey, Jim.
Yeah, absolutely. Yeah.
Hey, I just wanted to quickly go back. On your note related to the fact that the department doesn't have its own special notes under GLBA. If you go back a couple of slides, I just wanted to point out that, there's this. Oh, sorry. I actually went back a couple slides. Then I asked you to.
Sorry about that.
The goals for the security, the goals of the whole GLBA. And I wanted to mention that the department basically took these three goals and inserted the word student instead of customer. So when you look at the department's guidance, which we're going to discuss in a little bit, they include these three goals, but just instead of the word customer, they say student records. So they aren't doing much to expand upon what the FTC has written in the GLBA for the department, but we can get into that guidance in a little bit. Thanks.
No, thank you. And I think that does raise this issue because there are two terms you'll see used in GLBA. You'll see consumer and customer. And so consumer is someone who inquires about a financial product or service. Customer is someone who has this ongoing obtains a product and has an ongoing relationship. And so the Department of Education has replaced customer in higher education by saying, okay, it's student. But it does raise the point that someone could be still a consumer of yours. And so let's say you had an individual who applies for financial aid, but ultimately doesn't enroll. So there can be obligations regarding them. Because technically they're not a customer for GLBA purposes. They haven't obtained the product. And so they are not technically subject to the safeguards rule because the safeguards rule only applies to customers. This has been a sticking point under GLBA for many years. So things can get a little bit tricky in this space. And so if you want to discuss it, certainly I'm glad to go into it with you. But thanks for that, Katie, on the Department of Education. So getting back into it, so we talked about rulemaking. How is GLBA enforced? And typically, it's the same regulators that write the rules do the enforcement. So, and for the safeguards rule, it's going to be the Federal Trade Commission that is going to have the enforcement authority in the higher education space. There's certain the regulators don't always stay nicely within their swim lanes, and sometimes you can see a regulator in a particular case use other authority to attempt to enforce the requirements. And so you could see an agency with broader enforcement authority try and enforce a failing under GLBA or the safeguards rule other than the FTC. So it could happen. We've seen that from the CFPB, where they have attempted to get involved in data security issues where they don't have the authority under GLBA. So I would be aware of that. It's not necessarily only the FTC. The FTC is the agency you've got to watch out for the most, but it could be other agencies that try and enforce this stuff as well. So, yeah, the safeguards rule, the FTC issued their original version of the safeguards rule many years ago. I believe it was 2002 when the original one came into place. And the original safeguards rule was fairly short. It followed the same basic pattern that all of the financial services regulators use. They conferred with each other. They tried to do something that was consistent among them. And so what you saw from the banking agencies and from the SEC and from the FTC was a fairly hands-off approach, giving a fair amount of latitude to the regulated entities. So essentially, you do a risk assessment. You look at the nature and scope of the risks to your enterprise, to the non-public personal information that you have, and you put into place controls that are commensurate with that level of risk, that nature of risk. So that was the approach for quite a while. You go back about 5-6 years ago, and the New York Department of Financial Services, the regulator of financial services in New York State, issued their own essentially version of the safeguards rule, not under GLBA, but under their regulatory authority to oversee financial institutions that are licensed or chartered by the state of New York. And they took a very different approach. It is still risk-based. So it says you got to do a risk assessment and put controls into place based on that risk assessment. But we're saying that certain controls must be part of what you put into place. You have to have specific controls on the encryption of personal information. You have to have certain controls on access controls for users that are getting onto the system. And there were quite a few of these. And so it was a different kind of approach, not giving quite as much latitude, although there is still some, but saying you've got to have specific controls as part of your compliance program. And so then a few years ago, when the FTC started looking into amending their own safeguards rule, they looked at the New York DFS model and said, that's what we want to do. That we want to say you have to have certain specific controls in place. And so that's what they did. And so very explicitly, they looked to the DFS model, and they required a lot of those same controls. So what are they? So in looking at the new version of the safeguards rule, you have to have an information security program, often called an ISP, that does several things. So you have to, first of all, designate a qualified individual to oversee and implement the ISP. This is usually going to be a CISO, a Chief Information Security Officer, but it may be somebody with a different role. But usually this is usually a technical person, or at least technical knowledge that can kind of look at what security controls are being put into place to determine if they're commensurate with the risks. You have to do a written risk assessment of the risks and threats to the enterprise, and identify how you're going to control those risks, where you can control them, or at least where you're accepting a certain amount of risk if you can't necessarily control it completely. And then you have to do a number of specific things. Annual penetration tests to test the perimeter security of your system. Twice annually, you have to do vulnerability assessments of your information systems. Security awareness training for your security personnel, that's going to be more rigorous, but some level of security training for all personnel that have access to that non-public personal information. Performing risk assessments of your service providers. So entities that you have under contract that are performing services for you. You have to do a risk assessment of them. And then you have to put into place contractual obligations to essentially pass along those GLBA requirements onto them. You have to have a written incident response plan. So if you have a security incident, so this is broader than a security breach. So if you have something that may be a breach, how you're going to respond to those, who you're going to involve, it has to be included in that plan. And then finally, there is a requirement for written reporting at least annually by that qualified individual to the board of directors or some equivalent governing body, which is likely be some other body when you're talking about higher education. And I often get asked, okay, well, what are the most difficult of these? And I would say that there's a couple of these requirements that would be the most difficult. One is risk assessing your service providers, because most entities have hundreds or even maybe thousands of these. And so here you need to be looking at what are the service providers that we have that may have access to non-public personal information. So, who might be getting this information from financial aid at the school? Because those are the ones that we need to focus on, looking at what risks they pose, what controls they have in place, how secure their systems are, and then putting requirements in those contracts. And this can be difficult because the contracts don't come up for revision all the time. So you may need to do a contract revision that's out of cycle to, especially if you have somebody who's a critical service provider to you. Is that you may look at a contract and say, oh, that's not up for renewal for another couple of years, but these guys have a lot of sensitive data that we're sending on to them. You might have to reopen that contract and negotiate the privacy and the security requirements to it before that 2 years comes up. And then the last one here, the qualified individual is quite often the qualified individual knows the systems well. They know that they're great on the security side of things. They're not necessarily great on communicating that to the decision makers or the people who are ultimately responsible for addressing the risks of the enterprise. So it's important to make sure you've got somebody in place who not only has the technical skills, that can communicate that knowledge to others in the enterprise, especially those at the top levels of the enterprise.
Hey, Jim.
Yeah.
Hey, Jim, just before you get onto this last slide.
Yeah.
And some listeners may know, this is not my bailiwick. So, I'm in the same seat, I think, as a lot of listeners who don't do this full time. Some of our listeners probably are in the departments to do this full time. But at any rate, here's the point. That's a lot, boy. The bullets you just went through. I mean, this is a fairly significant administrative burden, right, for institutions of higher education. And, in my experience, if you're a professional at one of these institutions that's responsible for trying to convince your institution that, we not only do we need to comply with these things, but, we've got to allocate resources and invest the time and money required to do it and do it well. It can be hard. That can be a challenge. And part of, I think, motivating leadership or boards to understand and these requirements and invest in them is helping them to understand the consequences of failure, not only in terms of a regulatory consequence, but also, if you don't actually have the safeguards, if you're not actually doing these things and you're more exposed to an attack or less capable and ready to respond to one, what the consequences could be. So I was just this is a long walk, and I apologize for that. But my question is this: could you just take a minute here to talk about the value of it's one thing to do these things because they're required by law, but sort of setting that aside, the value of putting these protections in place, going through these exercises, getting these written policies on the books, and in your experience, the adverse consequences that you have seen in this industry and in other industries where folks are really not up to speed and caught unawares.
No, absolutely. I think there are many, the consequences can come in many forms. We'll talk in a moment about some of the enforcement actions. So when it comes to enforcement by the FTC, I'll get into a bit of that as to what that looks like. I think maybe a really underappreciated part of this is the reputational risks that an institution can face by failing to have these requirements in place. Is even if you don't get a significant fine from the FTC, which you can really have a black eye out of an incident because it makes it look like you didn't adequately protect information that is very personal, very sensitive to the individuals. It can affect your relationships with the individuals. It can affect the perception of your institution generally in the public, and it can affect the relationship with those who work at the enterprise, because they can be concerned if they don't think that the data is being adequately protected. If security is a significant enough value to the enterprise, that can impact those relationships. And so I think that is a very underappreciated part of this whole thing. Oftentimes these sort of shortcomings come about, or are realized at least, after there's been a security incident. So you experience some kind of hacking incident or a loss of data, and it can make the press. You can have obligations to notify state AGs, who then post on their website all the incidents that they've heard about. And so, and a lot of times those can be caused by not having the right security controls in place. So that's oftentimes how these come to light, is that they'll see the security incident, and then it may be an AG, or it could be the Department of Education, it could be the FTC that looks into, well, did you have adequate controls in place to avoid this in this before the incident happened? So I think those are I think there's levels of reasons why you need to be concerned about this. To this point, we've not had a significant amount of private litigation that relates to this, at least not successful private litigation. Graham Lease Bliley, thankfully, does not have a private right of action to it. But you can have actions under security breach notice laws, particularly in California. And certainly a plaintiff's lawyer, if they believe an institution did not comply with security requirements that they should have, and has a security breach, they're going to cite to that in the litigation and to bolster their case. So a long-winded answer, Aaron, to your question.
Many thanks.
Sure. So part two of the safeguards rule. So a number of other specific security controls that have to be put into place. These include access controls. And so this includes both making sure that only authorized people are able to get onto the system, but also, and somewhat more difficult, is to make sure that those authorized users only have access to the data that they need for their job functions. So, and quite often it's common to have, well, if you're an authorized user, you have access to all the data that's in the system. That may not be necessary. So you may need to cut off some of that access that somebody has access to. Managing data, users, and systems with your risk strategy, identifying what's higher risk, what's lower risk, and implementing something that's consistent with that. Encryption of information that's in transit, so it's going outside the systems, as well as encryption of data at rest. And that has been a difficult thing for a lot of enterprises. Sometimes it's easy to encrypt the data that you're sending out, but if you have data that's just sitting on servers or just sitting in the cloud, this is saying you've got to encrypt that NPI that's just sitting there, and that can be difficult. It can have a problem in terms of the system performance. That data has to be constantly encrypted and decrypted. Secure development practices for software, and this is going to, I think, vary widely by institutions, whether or not you're doing this, whether you're actually writing up software and using it, or you're using something that's off the shelf. Multi-factor authentication for where somebody's able to access NPI. So, and anymore, I think it used to be fairly easy, because if you just had two factors, and that could be a password and you use like an SMS code or something like that. Increasingly now, though, because those SMS code type things are not as secure, that regulators are saying it has to be something better than that. So think about what your multi-factor is and if it's commensurate with the risks to the data. Secure procedures for disposing of information. So I think this includes two things. One is not necessarily keeping everything forever, but two, then when you do dispose of some of that data that you no longer need, disposing of it in a proper way. I've certainly seen bad examples of printed pages that are put into a dumpster and then are blowing in the wind, for anyone to see. Change management, so you change things on your system, making sure that the system is still secure through those changes. And here again, maybe the most difficult of these controls. So controls to monitor and log activities of users and detect unauthorized access. This is essentially saying you got to watch what's going on your system, both what authorized users are accessing and what unauthorized people may be getting access to if they get onto your system. This can be a lot of data. If you're looking at essentially monitoring everything on the system all the time, this can generate an enormous amount of data. It can be very expensive, very difficult. So of all the control requirements I listed, in talking to a lot of institutions, this is the hardest one to put into place. And so now finally, I'll take a break there. Time for our first of the two secret words today. So today's first secret word is basketball. So if you could choose basketball from the list of three choices here, then we'll give you a few seconds and we'll move on.
That's a good,
Aaron,
I guess,
Aaron,
apropos for March Madness. Yeah, go ahead, Katie.
I was going to say, Aaron Lacey, are you responsible for choosing today's secret word?
I did not. For those who don't know, I am a Duke University alum, and Katie is a University of North Carolina Chapel Hill alum, and some of you may know they have a basketball team that was not invited to the NCAA tournament this year, and so when the tournament started, I called Katie and invited her to root for a team that did make the tournament, and then offered her a suggestion if she was interested in rooting for one from North Carolina that had a storied basketball history, and also one that is fully accredited. I'm still unclear as to whether UNC Chapel Hill. I think there's been some confusion on that point, and I've got some folks looking into it. But yeah, so it was good.
Well,
all right, guys.
I think that the Tar Heels felt like they had enough big wins in 2022, so we just kind of, hung
Is
back
that it?
this year.
Were they playing in the YMCA league again this year? I heard they did very well.
Yeah, they've got the best jerseys in the league.
Yeah.
All right.
All right.
Well, Jim, yep, you ready for me to move on? Okay.
Yeah.
Picked the UNC basketball team as your secret word. Thank you. Hello, everyone. Thanks so much for joining us today. I'm Katie Wendel, as Aaron mentioned at the beginning. And now that we've gone through the nitty-gritty of the GLBA requirements with Jim, I think it would be helpful to take a step back and understand how institutions of higher education really fit under these regulations. As an initial matter, post-secondary institutions are financial institutions per the GLBA, which is something that Jim touched on at the very beginning of this webinar. And the U.S. Department of Education has slowly been ramping up their oversight and specificity regarding colleges and universities and their responsibilities to follow GLBA requirements. They have issued a series of Dear Colleague letters over the last 8 years or so, and you'll see we have a couple of them linked here. And I guess it makes sense to talk about how schools are covered here. So post-secondary institutions and third-party servicers are obligated to protect student financial aid information provided to them by the department or otherwise that they've obtained in support of their administration of federal student financial aid programs, aka Title IV programs. I know Jim mentioned earlier that the requirements related to third-party servicers will not fully align, but I did want to make sure and emphasize that most of these requirements, according to the department that I've mentioned here today, do apply to institutions as well as covered third-party servicers that schools work with. In fact, schools are responsible for ensuring that their servicers are aware of the requirements and agree to follow them as well. So something important to think about there. I will generally just stick to saying school the rest of this webinar or institution, but you can assume that third-party servicers are generally obligated by a lot of these requirements as well. So each institution that participates in the Title IV programs has agreed in its program participation agreement, which you may know as your PPA, to comply with the GLBA safeguards rule. Additionally, under what's known as the Student Aid Internet Gateway Enrollment Agreement, the SAG, it's entered into by each Title IV participating school, includes a provision that the institution, quote, must ensure that all federal student aid applicant information is protected from access by or disclosure to unauthorized personnel. So those are, a couple of the hooks that the department uses to make sure institutions are complying with these requirements. For a little more background, in early 2020, the department announced that it intended to enforce the safeguarding responsibilities under the department's standards of administrative capability. So really, I guess that's the hook. They're saying that if you're not following the GLBA requirements, then you may not be administratively capable under Title IV requirements. But as we've worked with clients to follow these requirements, we've seen schools struggle with the practical implications of following the GLBA, especially with respect to categories of data subject to GLBA. So what is covered? The department has held roundtables over the last few years with leaders on this subject. I think Aaron mentioned, including our very own Jim Shreve. So thank you, Jim, for taking part in that and helping guide those discussions. So they've been talking about this for years. And in February of 2023, just last month, they did finally issue new guidance that provides some more clarity on several aspects of GLBA compliance for schools. Key to our discussion today and your efforts to understand what is covered in compliance requirements, the department explained the terms customer and customer information, which we talked about earlier in the presentation as well. Those are important words in defining the scope of GLBA compliance. So the department explained that for schools, customer information means, and again, I'm quoting, information obtained as a result of providing financial services to a student past or present. So this definition confirms what most schools had already been following based on the previous guidance issued by the department. GLBA compliance is primarily limited to student financial aid information, assuming that the institution properly restricts how such information is used on campus, as well as student business account information. So we'll get into a little bit later how exactly the department, well, not exactly, how we think the department will enforce these requirements. But one helpful clue on that front is found in this Dear CPA letter. We've also linked in the slide, CPA 1901, which outlines for auditors how they should approach this topic when they're doing a school's compliance audit. So they've included 3 things that an auditor needs to verify, and I'll just touch on them briefly, but it's just an important note as you're thinking through how to set up your school's program for compliance. The auditor should verify that the institution has designated an individual to coordinate the information security program. They need to verify that the institution has performed a risk assessment, and that then their plan actually uses the risks found in that risk assessment to create better security. So those are kind of the general guidelines that auditors at this point use to do your compliance audit on that front. So to further that guidance, as I mentioned, the Dear Quality letter from February included more specific notes regarding how a school should develop, implement, and maintain their written comprehensive information security program or policy. I know Jim noted the requirements for a security program under the GLBA generally earlier, but it's really helpful to note that the department in its February guidance identified 9 specific elements that must be addressed in an institution's information security policy. So I will very quickly just touch on a few of them, but certainly when someone is working on a school's program, they should reference these elements. So the first is that the school has designated someone specific to be responsible for overseeing and implementing and then enforcing the institution's information security program. And schools want to think through and be able to demonstrate that the person that they've designated has the capacity to do that within their specific role at the university and the capability. So, you know, don't just throw it under somebody else's job description and call it a day, but really make sure that that person has the capacity and capability for this important role. Schools should complete that risk assessment that I mentioned earlier, according to the department, look for holes in security that could result in the unauthorized disclosure, misuse, alteration, or theft of student personal information and financial information. You need to provide a specific plan that details those safeguards that will overcome those risks, or at least attempt to address them. Provide for regular testing of your program and system. You need to be sure that all of your personnel are aware and can implement the policies and procedures that you've established in your program. And then make sure that your third-party servicers are doing the same. There are also some specific things they mention. If your school has over 5,000 students or consumers, or if they have under, then you are not required to meet those. So just a note for schools looking at those requirements. Another helpful practice note is that the FTC did issue guidance in April of 2022 that provides more detailed information on each of those 9 elements. So helpful to look through that as you're putting your plan together. But just a note again that every school that's a Title IV eligible institution must submit evidence of compliance with GLBA as a part of the institution's annual student aid compliance audit. One more quick practical tip from working with schools on their programs. It's important to include in your program that you are going to evaluate and adjust your school's data security in light of the results of your assessment, which we've discussed, as well as any material changes to your operations or business arrangements, as well as any other circumstance that could have a material impact on your information security program, which could be an external factor or an internal factor. Just something to think about. So we'll get a little bit more into all of this later in the presentation, but the department confirmed in that new guidance that the new safeguard rules are effective June 9th, 2023. So that was a bit of a delay, but they will be effective on June 9th of this year. So important to make sure that you take a look at all this and update your plan accordingly before that date. They also indicated that any findings related to non-compliance will be resolved as part of the department's final determination of an institution's administrative capabilities. They've also indicated that they would be issuing additional guidance on the NIST 800-171 standards in a future electronic announcement. So we should all be on the lookout for those guidelines, which will be helpful as well to provide more details about what the department's really looking for. And I know I mentioned several of these things, but just generally encourage anyone setting up their security program or evaluating and updating their current program to review those documents that I mentioned and guidance provided by the department. Their end goal is protection of student data, which is every school's most important goal on this front as well. And they're also going to be, the ultimate arbiters of whether or not your school is meeting the requirements. And with this guidance, they're providing a bit of a roadmap for how they will do that evaluation and what they'll be looking for. So, okay, I will pass this back to Jim to talk more about the Federal Trade Commission and their role more specifically in all of this.
Okay, thank you, Katie. The FTC, as I noted there, they named rulemaking agency and primary enforcer for the safeguards provisions of Gramm-Leach-Bliley. They're an agency with very broad authority, to in different ways go after a lot of different businesses within the United States. But often with limits. So there's been some concern that they would overstep their authorities. And so they, for example, basically the FTC, it's difficult for the FTC to write a rule if they're not specifically authorized to do so under a statute. Otherwise, they have to use this much more cumbersome process called Magnuson-Moss to write rules where they're not given specific authority, and that process can take like 6 years to draft rules. They have a long history on cyber issues. They've been very involved. They've been a very technologically savvy regulator. And they've taken several actions for violations of Gramm-Leach-Bliley's safeguards requirements. They also have this authority to go after unfair or deceptive acts and practices under Section 5 of the FTC Act, which enables them to go after someone who's not necessarily a financial institution themselves. I would note that on these cyber actions, historically, there's been pretty broad bipartisan approval. Where vast majority of FTC enforcement actions, there is a consent order that they're resolved under. That consent order, it has to be approved by the commission. Commission consists of 5 commissioners, 3 from the majority party with the president's party, and 2 from the minority party. And most of these enforcement actions, if you look back, were approved 5-0 or 4-1 at most. And there's been general agreement on this. Things have changed recently. The FTC, their current chair of the commission, as Lena Khan, she has a very she wants to take a very aggressive approach to consumer protection, and there are 2 other Democratic commissioners Slaughter, and Bedoya, and currently one Republican commissioner who typically has urged a much more restrained approach and has increasingly dissented from the majority. That Republican Commissioner Wilson has announced her resignation, and she will leave the commission this Friday. So I think we can look for a pretty aggressive FTC in the coming months, especially during a time until we have some other Republican commissioners named. We're going to have all the commissioners from one party. I think we can look for a lot of 3-0 votes on enforcement actions with no dissents. And a lot of times the dissents in FTC cases give you some insights as to where they may or may not agree with each other. And those won't likely exist for a while. So as I said, we're seeing this partisan divide. We're seeing the FTC move into rulemakings that are not as clearly defined that they have the authority to do so. And so I think we're going to see more aggressive actions from the FTC, and that may lead to Congress stepping in. There's already been voices within Congress saying the FTC is being too aggressive. They're going out too far beyond their statutory authority, and there may be attempts to potentially rein in the FTC in this space. I noted here what the FTC does. I mean, they usually commence an enforcement action. It usually ends with a consent order. There can be fines. These can be significant. They've had security fines that have been in the hundreds of millions of dollars. They oftentimes include requirements that you have to have for your security program going forward, that you have to improvements that have to be made. An underappreciated part of it is that they usually include a biennial assessment for compliance with all of the security requirements for what can be 10 to 20 years. And this has to be an external assessment. And this can be very expensive, as is, as I said, truly underappreciated part of these consent orders. So another, going back to Aaron's, why you should care about this, this is definitely a reason to care about this. So Katie, do you have thoughts about what the Department of Education can do here?
Yeah, Jim, thank you. So as I mentioned, the department has said that institutions that are not complying with the GLBA or found not to have complied in their compliance audit would be found not administratively capable. And the department has indicated that once we're past June 9th, 2023, and I noticed a question about whether or not that deadline applies to all schools or just schools with over 5,000 students, and this does apply to all schools.
Hey, Katie,
you know what? Actually, I'm going to do the secret word.
Yes,
Yeah.
I was just going to say, let's do the secret word, and then we'll come back to it, because we got to get this in before the top of the hour.
Right. So we have to do the second secret word so that you can get your full hour of CLE. So the second secret word today is spring, which is lovely, lovely choice for today.
That's
at
right.
least in
It's
DC.
like,
DC
it's like next year, UNC is hoping to spring into the top half of the ACC. So you could use it that way in a sentence if you want, or if you wanted to. I mean, I'm just hypothetically. So they might try to spring into the upper echelons of college basketball. I can think of a lot of ways to use that word, actually.
Well,
so, would that be getting up to? Are you saying that they aspire to get to the level of my own law school, the University of Pittsburgh Panthers, and the
yes, yes, no question, no question.
There you go, Jim.
Oh, the UNC folk are already. They've already shut off. They already left the webinar.
Yeah, they all dropped off.
That's right. Enough of this.
That's fine. You Carolina grads can reach out directly to me.
There you go.
Need to talk to Aaron.
Very good.
All right. So that was our secret word. I'll go back. Yeah. So So basically, so the department has indicated in this most recent guidance that any finding of noncompliance in a school's compliance audit under GLBA will have the same effect as a finding of noncompliance in any other area of a school, of an institution's audit, and it'll have the same effect on an institution's participation, meaning that in cases where they've determined that a school's GLBA or their plan does not meet GLBA requirements, they will ask the school to come up with a plan to change their program to meet the requirements. However, if there have been data breaches as a result of the lapse in GLBA compliance, the department could do whatever else they feel like is required based on the effects of that breach. Also, repeated noncompliance by an institution may result in an administrative action taken by the department, which could include impacting the institution's participation in Title IV programs. Yeah, I think, I mean, generally that's what the department has indicated they will do right now if schools are not complying with GLBA.
Okay. No. Thank you, Katie. And let me just quickly kind of go into those last note here. States and GLBA. States can go beyond the GLBA requirements. We've certainly seen some states be aggressive in doing so. California, New York have done so. And so in the current legislative environment where things are having a difficult time passing in Washington, we're seeing more efforts put at the state level. So it wouldn't surprise me to see states consider enacting something more stringent on financial institutions under state laws. I would note that there is a bill in Congress that would change this provision of GLBA, and it has some reasonable chance of passage. I'd still put it less than 50-50, but it's in the House Financial Services Committee, and it has some chance of passing. That would introduce more stringent requirements under GLBA, but preempt the states from going further. So,
all right.
Aaron, back to you.
Yeah. Let me talk about just real quickly our TC Extra credit for those on the line. A couple of three things. First of all, we have a blog, our Reg Education blog, where we post pretty routinely information about what's going on. And here you can see one of our most recent posts actually was about this very issue. Happy for you to subscribe. Obviously, this is free, as are all these materials. This, I mentioned earlier at the outset, is part of our higher education webinar series. And every year we work pretty hard to bring together usually 5, 6, 7, 8, 9 or more webinars, depending on how active things are. And this year, we expect there will probably be on the higher end because there is so much activity occurring with the U.S. Department of Education. And here you can see just very recently, actually yesterday and today, both we did webinars on higher ed topics. Those are all free. They're also all CLE accredited. And if you listen to them after the fact, they're on demand. And if you miss one, you can always just pick it up at your convenience. Finally, we also have some compliance materials that we put out into the world. Typically, these take the form of a white paper or a checklist. We have a number of things that are out there. And I think, Jim, correct me if I'm wrong, we have a sort of a compliance product that's coming out around this topic, right?
We do. We have an FAQ relating to GLBA and higher education.
Was it part of that blog post? Is that where folks can get it, or is it forthcoming?
I believe it is up, but
okay,
I could be wrong, but I believe it is up.
Yeah. So if you haven't seen it, if you haven't seen that yet, if you go to our blog, the blog that was just on this prior screen, I think it's actually included as an attachment, and it's a pretty good write-up, actually. I've looked through it myself and learned quite a bit. So if you're interested, if you're listening in, I assume you are, in this topic, I really encourage you to find that blog post. And if you can't find it or you can't find the materials, just email me or Katie or certainly Jim, and we will make sure that you get it because it's there, it's free, and we would love for you to have it. All right.
Links
with
to all of that are also in the resource widget. Sorry, Aaron.
Oh, is it? Yeah. Oh, good. It's also in the resource widget. Excellent.
Yeah.
All right. Finally, our disclaimer, which is we're not your attorneys unless we're your attorneys. Okay. So with that being said, let me move to the Q&A here. We do have some questions, and I'm just going to moderate these. I'll go back to the beginning. Let's see here. So, understanding that the safeguards rule applies to customer information collected or maintained by institutions of higher learning as a non-banking, but nonetheless financial institution. Our question is whether or not the requirements must be applied across all aspects of the university, or is it permissible to apply it in a more segmented manner? In other words, just to the bursar's office or the financial aid office, presumably those that are sort of responsible for the financial institution designation.
That's a great question. Yeah, go ahead.
It is a great question. I mean, I think it speaks to the great benefit to, I mentioned before about access controls, making sure people only have access to data that they need for their job functions. So it applies to NPI, so personal information that's obtained by an institution in providing a financial product or service. That financial product or service is financial aid. So to the extent that information around financial aid can be limited, to particular people, particular systems, then you can limit the scope of the requirements around that data as well. So to the extent you can wall it off, that's going to be very much to your benefit.
Yeah, and I will add, most of what I spoke about was focused on federal student financial aid, but these requirements are in place as well for non-federal student financial aid. So anytime an institution is working with a student for a private loan or financial implications of any sort, these guidelines need to be followed.
So another great question. Does the privacy portion of GLBA overlap with FERPA or supplement it? Schools are already held to FERPA guidelines to protect PII.
It is another good question. I would say that it supplements FERPA, although, well, it really does both. It's certainly, a lot of the data, the PII that is protected by FERPA will be falling under GLBA requirements as well, but GLBA, I think, really expands on the data that needs to be protected by a school. Jim,
right. I think that one very beneficial thing is there is we talked about the division between the privacy requirements of GLBA and the security requirements under the safeguards rule. For the privacy provisions of GLBA, thankfully and helpfully, we've seen the FTC and Department of Education say compliance with FERPA is compliance with the GLBA privacy requirements. So then that means that higher education institutions don't have to then have their own GLBA privacy notice and go through those requirements that other financial institutions would. Their FERPA compliance serves for that.
Yeah, and I'll just add, keep in mind, FERPA, I mean, on the one hand, it's focused on students, right? And not information that may pertain to faculty or staff or under folks at an institution. On the other hand, FERPA covers all kinds of information, right? Not just financial information. It's any sort of educational record. So, Jim, Katie, correct me if I'm wrong, but I would think in some respects, educational records is an extremely broad concept that goes well beyond, I would think, maybe what GLBA is focused on. So that they overlap, but they sort of also get at different areas. Is that fair?
Yes.
That is fair. Yeah.
All right. Not bad for the non-expert. Let's see. Is there a permissible way to opt out of being covered by GLBA and these requirements for an institution of higher education?
Well, Jim, you can correct me if I'm wrong, But I think the permissible way to opt out would be to opt out of participating in Title IV programs and not sign your institution's PPA to be a part of that.
Yeah, I mean, and actually, it would probably even go beyond that because the financial, you'd have to not have lending programs to students because that's the financial product.
Yep.
So even if you weren't under federal financial aid, if you were in some way providing loans, you'd be a financial institution.
Or maybe even just extending credit in the way of payment plans and things of that nature.
Right.
Yeah. Probably not a convenient way as an institution of higher education to find your way out of this. Certainly there's no opt-out option that is available. So there's not a rotary button somewhere on a website that you press to avoid compliance. Right. Is it anticipated that the additional guidance related to NIST might be a crosswalk to the NIST standards or new requirements of NIST that might now be applicable, which were not previously applicable?
Okay, I can respond here. So NIST, the National Institutes of Standards and Technology, produces a number of standards in a number of areas, including relating to cybersecurity. The 800 series is a whole slew of cybersecurity related topics. And one of them in particular that comes up frequently is the 800-171 guidance, which is a standard designed for government contractors. It technically is completely independent of the safeguards rule and requirements, but what the Department of Education has said is that 800-171 can be a useful tool for complying with the GLBA requirements, even though they're not technically related, because they cover many of the same subject areas. And then there was a mention of crosswalks, and crosswalks are tables that essentially draw an arrow saying under this particular standard, there are dozens and dozens of cybersecurity standards out there. It will compare two of them and say, okay, this requirement in this standard is essentially equivalent to this requirement in this other standard, and draw a line between them. I haven't seen one done yet on the new safeguards rule requirements and NIST 800-171. It could be out there. There are a lot of privately produced ones, and so a good search might come up with one, but I'm not aware of it at this point. And I don't know that the Department of Education is planning on it. I will say, having been involved in discussions with them, they are quite enamored of 800-171. They think it is a very good tool to use, even where it's not technically required.
Yeah, Jim, that's a perfect segue into what I was just going to add, that I agree. I'm not sure we'll see a crosswalk necessarily, but the department specifically in its guidance did encourage schools to begin incorporating the requirements, the information under NIST 800-171 into its program as soon as possible. They also noted that they will issue guidance related to that, and that compliance with the GLBA requirements is not the same as compliance with NIST 800-171. So they're separate, but the department does encourage schools to use it as a resource to help bulk up their plans.
All right, guys, you got 90 seconds left. All right, so lightning round, quick answer on this. Do you see the department adopting CMMC version 2.0, which is based 100% on NIST 800-171?
CMMC to probably not. I think that is, but I think the Department of Education likes the tiered approach. CMMC understands that that you can have different levels of compliance requirements based on the risks that an enterprise faces. And so a school, a research university of 60,000 people might have different concerns than a small, specialized school, of a couple of dozen. So I think there is we might see something that uses that CMMC tiered approach, but CMMC to itself might be a little more, because that's designed in the Department of Defense space, so that might go beyond what education wants to have.
Jim, out of time. Thank you, sir. Hey, thank you to Jim and Katie for everything today, and for all our listeners. We hope you're well and that you will continue to be well, and we'll see you next time.